So today we have three very distinguished free speech experts who are versed in both the domestic and the international aspects of everything that we're going to be talking about today, including incitement, social media bans, and censorship as it plays out at home and abroad. I want to begin by thanking you all for making time on very short notice to do this. Seth Berlin is an attorney with Ballard Spa and a longtime defender of many media organizations, as well as teaching First Amendment law at Georgetown Law Center. Michael Posner is a former Assistant Secretary of State in the Obama administration for human rights. He also founded a Lawyers Committee for Human Rights. He's now at the NYU Business School, where he's been focusing on social media behavior, social media companies' responsibility, and the human rights aspects of what social media companies do or don't do. And our third guest, Jillian York, is coming to us from Berlin. Thanks for joining us. Jillian is an expert on international free speech. She will talk about, explain to you Section 30 in the ins and outs of Section 230, the famous Section 230. And she'll also be able to answer any questions that you might have about how the international aspects of what the United States does will affect social media companies abroad, and also how our friends over in Europe and elsewhere are looking at the United States and wondering why we have the kind of bizarre to them First Amendment laws and decisions that we have. So let me begin. Let me turn this over to Seth. Seth's going to give you a briefing. We're going to do law first and then policy. So this section is just about the law. For those of you who studied this in journalism school, but maybe slept through it because you thought it wasn't that important, it was kind of preposterous that this would ever really be an issue. We're going to start with the basics of the definition of incitement and then spiral on to the more difficult issues. So thanks to all of you. Seth, over to you.
Thanks very much, Sunny. It's great to be here with all of you today and with Jillian and Mike. I have to, as lawyers have to do, I'll start with a disclaimer. I am at a firm, Ballard Spa. I represent a lot of different clients, including many of the news organizations who are represented on this call. I also teach at Georgetown. What I say today is obviously my views, not necessarily those of Ballard Spa, its clients, or Georgetown. That's the end of the disclaimer. Let me try, if I can, to set the table for today's discussion by talking about the First Amendment in two respects. Primarily, I want to talk about incitement because it's been in the news. As you all will remember from civics class, the First Amendment protects five things: speech, religion, assembly, association, and petition. We're not going to talk much about religion today, but the other freedoms all sort of work together to protect speech, association, petition, and assembly. And those things are all in play in what's been going on in the news. There is a common understanding of what it means to incite somebody else to engage in violent conduct or unlawful conduct. And then there's a legal test. And the legal test is purposely difficult to satisfy because it's designed to provide a maximum amount of protection for freedom of speech. And it asks a sort of unusual question. When we think about the law in most areas, people are responsible for their own conduct. And incitement asks really a different question, which is, in what circumstances can we hold a speaker responsible for something that might have inspired a listener to act? And it's sort of asking that question about when is the speaker also responsible. It's a sort of an interesting way of thinking about it. To provide maximum protection for speech, the test for incitement under the law has three parts to it. First, the speech has to be directed to. Second, likely to. Third, cause imminent lawless action. So you have directed to, likely to, and imminence. The directed part really asks the question, were you trying to do it? Was your speech intending to incite lawless action? The likely to is, in the circumstances, was it reasonably likely that would be the result, right? So it's got both a subjective component, were you trying to do this, and an objective component, was that reasonably likely to happen in the context in which you were speaking. The third part is imminence, which is designed, again, so that it applies in situations where you're caught up in the moment, right? Where you have sort of a gut response to what's going on around you, and you get caught up in the moment. And it's not really a thinking response on the part of the listener, but almost a reflexive response, right? And so those are the three parts of the legal test. The two cases that are probably the most important US Supreme Court cases on the subject protect speech, a difficult speech across the political spectrum, right? So the first case is a case called Brandenburg versus Ohio, and it involves speech that was at a KKK rally, one side of the political spectrum for sure. The other is a case called NAACP versus Claiborne Hardware, and it involves speech by civil rights organizers from the NAACP at a rally to organize a civil rights boycott. And one of the things that's important for, and we'll get to this in the policy part of the program, but one of the things that's important to recognize is when you think something sounds like incitement, you have to think about whether the test that you're applying, how that would apply with speech that you might find more palatable, because that's really the exercise for free speech lawyers, is to come up with rules that apply regardless of the content. Now, this gets to the tougher part of the question, which is, I've been asked by Sonny and by a lot of other people, is what President Trump said at before the insurrection at the Capitol incitement, based on the legal test, is what he said and what his allies said. I guess I should broaden that slightly. And it's hard to graph the legal test onto that I just outlined onto those circumstances for two reasons that are sort of peculiar to that circumstance. One is that you're dealing with, in a lot of cases, this is true in incitement cases, it's true more broadly in free speech cases, you're dealing with ambiguous or coded speech, right? So there's a lot of people who are saying what President Trump's words actually weren't directed to and likely to incite action. And other people are saying, we read into what he was saying a clear message that was designed to say to the people assembled, go down to the Capitol and engage in lawless action to stop the vote that is taking place there today. And that disagreement is really at the heart of it, because you're dealing with speech that is ambiguous. He says, we love you, but go home. Well, what does that mean, right? And so you can find in that, both support and disavowal at the same time. Mm-hmm. So what that essentially comes down to is, in this circumstance, that really gets to the likely to prong, right? Was it likely to happen in this context, right? And some people would look at that and say he's talking to thousands of people, many of whom are armed, who he's riled up and sets them loose to go. And there are other people who say, well, he was just engaged in a peaceful protest, right? So that right there is the nub of it. The one other problem that this case has, which almost no other incitement case has, is that the speaker is the president of the United States. And when you are encouraging somebody or allegedly encouraging somebody to engage in lawless action, if you are the chief law enforcement officer and commander-in-chief of the country, that message, even if you do it with a wink and a nod, comes with it the underlying message that you are less likely to be held accountable or prosecuted if you in fact engage in lawless action, and it makes it therefore more likely that you would do so. And that again speaks to the likelihood of prong. So, perhaps the difference between being the president and saying something and being an ordinary citizen is it comes with the imprimatur of being a high government official. And that is another sort of distinguishing fact that as people think about in this situation, people should to think about. So that's really what I have to say about the incitement test and its potential application here. I would commend to you, which I think we're making available, Sonny can tell you the mechanics of this, an op-ed piece by Suzanne Nossel of PEN America in the Times, which describes all of what I just said in some detail with citations to the various cases and doctrines. She takes the position that this is probably not incitement under the legal test. I think it's a close question, but it's a good reminder of the difference between sort of the common understanding and the legal test, and the reasons why the legal test is intended to be particularly demanding to protect speech. With that, I think I'll just shift briefly and set the table for the other issue that we're going to talk about today, which is social media bans. And there'll be a lot of policy discussion about this, and I'm not going to try and short circuit that, but let me just put a couple of legal principles on the table. The first is that the First Amendment restricts the government. It doesn't restrict private actors, right? So when people say, this is a First Amendment problem that Facebook or Twitter or Amazon Web Services has taken down either a social media site or President Trump's accounts, that is their choice as private actors under the First Amendment. If you think about this, the first three words of the First Amendment are Congress shall make. It applies to the government. And in the absence of that, there is not a First Amendment problem. Another example that's recently been in the news is Josh Hawley and saying that it was a First Amendment violation for Simon & Schuster to decide not to publish his book. Not so. Simon & Schuster is not governed by the First Amendment in that respect. It restricts government action. Now, there have been a lot of concerns about whether we want to concentrate that power to decide in a few people, in a few companies, the Facebooks, the Twitters, the Amazons of the world. And that is potentially a competition problem, right? We don't have enough people making those decisions. I'm not an antitrust lawyer. There are antitrust cases pending against Facebook by 48 attorneys general and the FTC. And all I can say to you is that it is rare for me as a lawyer to see 48 attorneys general agree on just about anything. So that tells you something about that case. But I would submit to you that that's really fundamentally a competition problem, not necessarily a speech problem in terms of the limitations that the First Amendment has of only applying to the government. And I think I'll just stop there and see if there are questions. I know Sonny wanted to open it up to see if there are law questions before we get to the policy, and I'll stop there.
Right. For those of you who are just joining us, we're dividing today's program into two pieces, law and policy. Seth Berlin has kindly given us a briefing, and he's going to answer some questions about that you have about the specifics of First Amendment law. And then next up is Michael Posner from the NYU Stern Center of Business and Human Rights, who's going to talk about the social media part of it. So please raise your Zoom hand if you have any questions that you want to ask about the First Amendment, including how it applies to stories that you're working on. And by the way, we understand that there are people on this call who are working on stories on the local level. So if you have a case in Tennessee or something that you want to know how this applies, please feel free to ask and raise your hand. Okay, I don't see any questions. So but please feel free to interrupt. We're not going to take questions at the end. We'll take questions all the way through. Okay, so now I'd like to turn it over to Mike. Mike and I actually worked with Suzanne Nossel at the State Department, and we dealt with these questions internationally. Mike is a distinguished lawyer himself, but he's going to talk about the questions with the social media bans, the takedowns. What is their legal responsibility and what is their moral responsibility? Over to you, Mike.
Great. Thanks, Sonny. And it's great to be here. I want to pick up where Seth left off on the question of the First Amendment and free speech and how it applies to the social media companies. I'm a big believer in the First Amendment, and I believe in the U.S. approach that takes a quite expansive view of what constitutes free speech. Having said that, as Seth pointed out, it applies to the government. And the social media companies have entered this discussion, and as it's evolved, have played a somewhat complicated, they're in a somewhat complicated place. I want to just lay that out. The assumption has always been that these are public, in effect, common carriers. They're taking information from others and spreading it. And that makes them very different from a news organization that has editors and publishers, as you all do. And they have said that because we're not publishers, we shouldn't be responsible for what goes on our site. They've said that broadly. And again, I know Jillian's going to talk about Section 230, but they've said they've been protected by the law in allowing them not to be held liable in a court. But they have, in fact, moderated content in all sorts of ways, some of it relating to the law. You can't have child pornography. You can't have things up on the site that promote lawlessness or violate the law. There are a range of things where they've, in fact, taken the initiative and said, we're not going to allow that on our site because it's illegal, or in some cases, it violates their community standards. And so we saw last year when the pandemic broke out, a number of the companies, and I'm talking here mostly about Facebook, YouTube, which is part of Google, and Twitter, they all of a sudden recognized that there was a massive amount of disinformation about cures, about vaccines, and they began to patrol their sites to take things down. So they take the position, we're not publishers, we want free speech, we're not arbiters of the truth. Those are Mark Zuckerberg's words. You hear that over and over again. We don't want to be in the position of determining what's true. And we've said, and I believe that they are in a somewhat, they're in a third category. They're not news organizations in a traditional sense. They're also not like the phone companies or plumbers just running pipes. And so part of, I think, what's going on now is we're trying to define what's that third category. What does it mean to be Facebook or Twitter when you have the President of the United States or QAnon or others throwing disinformation into the mix in massive amounts, and an environment, a public environment where people are taking that disinformation, the election was stolen, and engaging in an insurrection. And the last point I would make is that I think these companies need to take greater responsibility. I don't want government determining content. I think that is a violation of the First Amendment, and it doesn't make sense to me. But I think we've got to find ways for these companies to assume greater responsibility for dealing with disinformation and other harmful content. This has now come to a pitch now. It's at a higher level than it's ever been, where there is such a massive amount of disinformation, especially in the political sphere, raging on these sites, and it's causing action, which I think is undermining our democracy. Last point, just a last footnote point. I was not happy that Twitter made the decision to permanently ban President Trump. I think the actions need to be forward-looking, current and forward-looking. That is to say, the job is to prevent harms, to prevent violence, to prevent bullying or whatever. It shouldn't be punitive. And so to me, if the sites, and now Twitter and Google, YouTube and Facebook have all taken down President Trump's accounts, I think you can do that and say indefinitely, or until he changes his behavior. He may never change. I would predict he won't. But I don't think a permanent ban, which is really a punitive action for past action, makes a lot of sense. Let me stop with that.
Okay, we've got two great questions. Mike, I just want to ask you, push you on one point, which is when you say you think that the social media platforms should be, held accountable, can you just say a few sentences about what form of accountability? Are we talking about civil penalties? Are we talking about regulation? How?
I think that's going to be the question of the next months. And there are some proposals in the Congress. Again, Jillian will talk about Section 230. There are a range of legislative proposals that in some ways would limit it, some would eliminate it. I don't think I don't favor the notion that you just wipe it off the books, but there's some ways in which you can make it more conditional or add some categories to the things that are exempt from that liability protection. There's also a whole range of things relating to transparency. There's a bill called the Honest Ads Act, which would require much greater transparency about political ads or other ads, and in terms of who's actually paying for those ads. I think there's a wide range of things the government can do to make the companies more transparent about what they're doing, what they're taking down, how their algorithms are now working. And then there's a regulatory piece, and I think it's an open question. We have a regulatory agency that deals with broadcast, Federal Communications Commission. We have a regulatory agency that deals with consumer protection, the Federal Trade Commission. Is there some expanded mandate in one of those, or do you need some kind of a new regulatory body? So I think we're going to see movement in all of those directions, and we're going to have to see where it lands.
Okay, well, let me stop and take some questions. The first one, again, this is a law question. Jillian, perhaps you could answer this one, and Seth weigh in as well. And this is about the blurring of the line that you just mentioned, Mike, between, what is a utility, what is a publisher, what is a plumber? So this question's from Tom Herman at the Wall Street Journal. Welcome, Tom. What is the law on allowing reader questions to be published? If a news organization allows all reader questions to be published, is the organization liable? What if it curates questions and removes offensive comments? Does that make it liable? Jillian, do you want to take that one first, and then Seth, you can weigh in as well?
Yeah, I'm going to do my best here. And if lawyers, please stop me if I'm getting this wrong. So my understanding of it, and I think that this is a really important key part of Section 230, is that it doesn't just protect Facebook and Twitter, it also protects website owners. So if I'm a website owner, and I have my own site, and I don't moderate my comments, I can't be held liable if somebody's in there, posting incitement, for example, or posting, other types of speech. And this is really important because what we've actually seen in other countries is blog owners being held liable by their governments for comments that readers post. There was a case in Thailand about 5 or 6 years ago that was really famous around this. So my understanding is that a newspaper's website would be treated the same way as Twitter would under the law. But again, lawyers, please correct me if I'm wrong there.
Seth, do you have anything to add to that before we go on to some other First Amendment questions?
Let me just add one more stroke to that, which is, Jillian's absolutely right. So, this protects, reader comments or questions on a website. It protects the comment sections of the, of the Post and the Journal and the Times. It does, and it's done, and sort of to answer the other piece of Tom's question, Section 230 came out of an environment in which previous court cases were essentially holding website operators liable if they moderated and not holding them liable if they didn't moderate, and it provided a disincentive to moderate. So one of the things that people forget about Section 230 is that it came out of an environment which was actually designed to allow, let's say the Journal decides to moderate its comments, to allow it to take a particular comment down without it being responsible for every single comment that is then posted for a time memorial, because that is, they're not assuming a duty to do that moderation. And that's one of the things that Section 230 protects.
Okay, Seth, one more question for you about incitement and the standard for incitement from Sandra Peters. If what the president said on January 6th does not pass the test, the legal test for incitement, then theoretically, what might pass the test if the speaker is the president of the United States?
So the easy answer to that question, I'm sorry to give you like sort of a lawyer's easy answer, but the easy answer to the question is if the president had gotten up in front of a mob of people and said, I want you to go down to the Capitol and storm the building, right? And in circumstances where he got the crowd riled up and therefore the speech is directed to doing that, it's in circumstances where that's likely to happen and the result is imminent, right? That passes the test. And the only thing that's different here is that the speech is somewhat more ambiguous, right? And so that's the sort of free speech problem in this case. So if in fact, when I teach my class at Georgetown, I'm going to probably pick a different example. I actually have as an example of incitement is if you're standing in front of the Capitol and you rile up the mob and say, storm the building. It's amazing that what I thought was a preposterous example wasn't a preposterous example, but that would be a clear case of incitement. And the only thing that makes this sort of a tougher argument to have is that, his speech is sort of all over the map. I want you to behave lawfully. We love you. Go home, right? What does all that mean? And so you have this sort of stew of things that could be viewed as inciting and other things that could be viewed as not inciting. And if you're a person who's thinking about bringing that case as a prosecutor or as a private lawyer bringing a civil lawsuit, let's say, for example, on behalf of, Officer Sicknick's family who was killed there. If you're, thinking about that case, you're thinking, can I make this case that despite the fact that the language was ambiguous, it actually was both intended to incite the crowd and in circumstances reasonably likely to do so.
Okay. And Seth, could you just say a little bit more about the coded language problem that you referred to earlier? and the propensity for criminal actors to use coded language, specifically like when they think they're being wiretapped by the FBI. And you also mentioned the case of Michael Cohen. Could you just say a little bit more about that?
So, look, when Michael Cohen testified in front of the Congress, he basically told them that, President Trump never asked me directly to do anything wrong, but it was always understood that what he wanted me to do, right? And people, that's how communication works. It works with nuance. It works with language. I mean, look, there was Jillian can speak more about this because of her international focus, but in Rwanda, there were radio broadcasts that said it's time to cut down the tall trees. Perfectly innocuous speech. Everybody understood that meant go out and kill Tutsis, right? And so the fact that the speech is ambiguous or coded is not necessarily disqualifying, but it is, and it ought to be judged with a high, to a very high standard, because otherwise you allow circumstances where in the next case somebody says, you said something that was not at all insightful, or intending to incite something. Insightful, I guess, has a different meaning. Intended to incite something, but we still somehow find that there was meaning there that meant that, and that provides a formula that when you're not talking about the president, you're talking about somebody else, really provides a danger to free speech, both here and if you apply that test in foreign countries. There are lots of places in other parts of the world where they apply that kind of test to suppress speech, and so there's a reason to be nervous about applying that willy-nilly.
Okay, we'll talk about foreign countries in just one moment. One more question from Paul Efron, and this is Seth, back to you on the second part of your summary. If government dictates policy on social media sites, do you think then that First Amendment protections apply in light of the government involvement?
Again, sorry to give a lawyer's hedge. It sort of depends on what those regulations are. Generally, the fact that the government regulates something doesn't turn the party being regulated into a state actor, into a government actor that would be constrained by the First Amendment or by other laws where you have to have where the government is the one who's acting. So that's sort of a general answer to that question without more specifics. That you could imagine a circumstance where that might not be the case, but generally I think that's a good answer for that.
All righty. I'm going to turn this over to Jillian. Journalists, please post your questions, raise your hands. We are giving preference to journalists on deadline, so wave your hand if you need an answer quickly. Okay, Jillian, over to you. Thank you.
Hi, well, thank you so much for having me. This has all been great commentary, and it's covered some of the ground that I was going to. So I will try to talk in a straight line, but I may have to jump around just a little bit. So the first thing was around 230, and I think we've gotten a good explanation here of what it is. But just in terms of some of the reporting that I've seen coming from Europe, I've gotten a lot of questions this week around some of the things that US politicians like Ted Cruz have said about platforms needing to be neutral. And I feel like that's the first thing to clarify, even though it's been said already, that what 230 really does is it gives platforms protects them from liability. It doesn't require them to be neutral. And as Seth said already, that interesting distinction there that basically gave platforms more power to not moderate if they chose to. And so EFF's position on this is that, we would like to see a multitude of different types of platforms and different types of moderation, from unmoderated platforms to, the niche platforms like Ravelry, the knitting site that banned political speech last year. So I'm based in Berlin, as you mentioned, and the key difference between the US and Europe in terms of regulation and in terms of the comments from Angela Merkel earlier this week, where she criticized the way that the platforms have behaved, is that essentially, what I've experienced here in Europe is that there's an idea that it should be states and not companies that regulate speech, whereas the general idea in the US is that it should be companies. I'll be perfectly frank, from my perspective, I think that they're both kind of troubling propositions, although I'm also, as the other panelists have said, opposed to state intervention in this sense for some of the obvious reasons. And when we look at the Trump administration, it's not hard to see that if we had, given them the power to censor, they would have turned that against certain groups while enabling their fans to continue, the kind of speech that they have been. So I think that that's a really important point, but I also think it's important to note that these platforms don't get the rules right either, and that we're right to be critical of them, even while condoning their self-regulatory practices. And when we look specifically at politicians, I think that the thing that I find most troubling is that the way that the platforms have dealt with this is to actually give elected officials and other public figures a wider berth in what they're allowed to say on these platforms. So what I've been doing for the past decade is tracking the ways in which platforms go after ordinary individuals for their speech while, while enabling or allowing world leaders and other political figures to kind of say whatever they want. And this is actually policy at these platforms. I'll give you an example from Facebook where Nick Clegg, whose title escapes me at the moment, but he's high up on their policy team, he actually said, would it be acceptable to society at large to have a private company in effect become a self-appointed referee for everything that politicians say? I don't believe it would be. Now, what I find troubling there is that it's kind of a galling statement from a company that has always been happy to be the self-appointed referee for things that the general population says. And I've documented over the years numerous examples of Facebook and, of course, other companies as well, making value judgments about different types of speech from regular individuals. And some of the things that I've seen removed over the past few years include any type of nudity or sexual speech. And that's not just in the wake of Sesta Fosta in 2018, but prior to that as well. Activists in other countries are regularly removed, but also in the US. Just today, I saw a US person on Twitter who was suspended because they said that the world would be better without it was a word that is an ordinary word for a political ideology, but it wasn't hate speech. And that's, I think, speaks to Seth's example about some of these platforms going too far in what they take down and providing more scrutiny to ordinary citizens than to politicians. And then just one last point on the kind of the issue of ambiguous coded speech and dog whistles is, I think, the term that that I would use here, is that a lot of times, in Europe, we do see governments go too far around this. And one of the most troubling cases over the past few years was in the UK when they were prosecuting a person who had, as ridiculous as this is, taught their dog to do a Hitler salute. Of course, not a great thing to do with your dog, but also intended as a joke and prosecuted as incitement or hateful speech. And so we do want to strike a balance here. I guess the last point that I was trying to say here is just the influence that the US has an outsized influence on what these platforms do. And so while we see that they were very slow to act and the US government had no involvement that we know of in the removal of Trump himself, the US does have standards for the rest, or different standards for the rest of the world. And one of the examples that we were chatting about before the panel started was back in 2012. Many of you will remember the Innocence of Muslims video, which was viewed by a lot of governments around the world as incitement, and many of them did ask companies to take the video down. But so did the US State Department. They actually asked YouTube to remove this video out of fear that it would cause riots in other parts of the world. YouTube said no at first, but then they specifically geo-blocked the video in Egypt and in Libya, where they thought that people would be incited to riots. So I think that it's also sort of troubling here that the US sometimes views other people outside of the United States as more likely to commit violent acts, but then gives leeway to people in the US. And so I guess my conclusion on that is that what we need to see from these platforms is even-handed treatment, more inclusion of members of civil society and users from around the world, and of course, much more transparency and right to remedy. So I'll stop there and see if there are any questions.
All right, so we're open to questions. I want to turn this, while we're waiting for questions, First Amendment questions to Seth. Mike, I want to turn back to the platforms. You've said for a long time that the platforms are just allowing, massive amounts of disinformation. We've talked about incitement and specifically, illegal hate speech and illegal actions. Since we're veering all over the place, let me just ask you to say a few words about disinformation, because the platforms have been much more willing, allegedly, to take down disinformation, but really unable to do so.
Yeah, and I will say, while I agree with Jillian that there are instances where the platforms have gone overboard in taking things down for ordinary citizens, they've treated leaders, political leaders, differently. I think there's a much larger problem of the ambiguity in which, or the confusion in which the platforms have dealt with disinformation, provably false information, especially in the political sphere. Things like, the Pope endorsed Trump, or the sex ring that Hillary Clinton was running in the basement of the pizza shop, or a lot of what's going on with QAnon. The Holocaust never happened. There are many, many examples where they basically said, again, we're not arbiters of the truth. We're going to allow things up there. People can debate them online. And while I agree with Jillian that it's awkward or uncomfortable to think that the companies can make those judgments about information that's dishonest and deceitful, I don't want the government to do it. I don't see that there's a real third alternative that's actually working or workable. There's so much information, so much disinformation online. It is so provocative. It is undermining, in my judgment, our democratic discourse. Only the companies see it in real time, and when it goes viral, Stop the Steal would be the most recent example. It creates an environment where people are mobilized to act in ways that are wrong and often illegal. What we saw, the attack on the Capitol was prefaced by a range of people who believed, because they were living in the online world, that there was a stealing of the election and that their candidate had lost, and they were going to right the wrong. That's the world we now live in. And I think the companies, Facebook, YouTube, Twitter, have been massively irresponsible in not being more aggressive in taking some of that down or reducing it. There's a range of things they can do, but I don't think they're anywhere near where they need to be in terms of being better moderators of that content.
Jillian?
Yeah, I mean, I think that those are all fair points. And I think, I think we can see them as irresponsible in kind of both directions, both in terms of the misinformation, but also, I think that they've also been irresponsible in increasingly using automation, which is not up to par in dealing with the context of either disinformation, but also of other content, right? So I think that it's, that's fair enough, but I think it's also very irresponsible of them to, to pay more attention to the US and Europe than to the rest of the world. They don't have content moderators that can deal with languages in a large number of countries. The fact is that, politicians in other countries are getting away with all sorts of things on these platforms, while Trump is getting, I can't tell you how many press requests I've done this week, but nobody ever asks me about the hate speech that politicians in Lebanon are engaging in, or in India for that matter. So I think that these are all important points, but I think that maybe there's not an effective third way yet, but there is so much more that companies could be doing. Facebook's a multi-billion-dollar company, and they spend their money on acquisitions instead of better training human moderators.
Okay, two related questions. Let me start with you, Mike. Question number one is that you mentioned the Stop the Steal. The social media companies, we're now away from law and into policy, but the social media companies are under attack for allegedly being very biased in favor of liberal speech and against conservative speech. And I wanted you to address that. And the second issue, though, is that, again, who is the arbiter of disinformation, particularly now when the media, often fails to investigate and doesn't or can't bring facts forward, or simply overwhelmed with it. Can you weigh in on those?
Sure. Let me take the second question first. I don't think there's an easy answer to that question, but I do think as Jillian just said, I think the content moderation function, the way the algorithms work, there are a range of things that companies can do to take greater responsibility for determining what's on and off their platform, or what gets demoted, or what gets juxtaposed with something that's truthful. So I think there's a much greater latitude that they should claim to say, we are going to make judgments if something is provably false, it's going viral, it's leading to consequential action. I think they've got to take greater responsibility for that. The first question again was, Sunny, just...
It was the allegations of conservative bias by the platforms, that they're biased against conservatives, and it cuts both ways, that they didn't do enough to take down Stop the Steal, or that they were bending over backwards, or that they are in fact biased. How do we look at this thicket of mess?
So my colleague, Paul Barrett, who's a longtime journalist, has written a report that we're going to release in a couple of weeks exactly on this point. And I don't want to scoop the report, but it basically says overwhelmingly what's on the sites, what circulates in this sort of political sphere is coming from conservative perspectives. The companies have actually bent over backwards not to be prejudicial or to go after conservative commentators, so much so that it took them a very long time to take down InfoWars, Alex Jones, or QAnon. And so in 2 weeks or 3 weeks, we'll put that report out. But I think the facts don't support what Senator Cruz and Hawley are saying. Overwhelmingly, I think the companies have bent over backwards not to discriminate against conservative viewpoints.
So let me ask a question about disinformation. We have two related questions about disinformation. And Seth, maybe you can talk about this. First of all, is there any legal definition of disinformation, or is this like so new that we don't have a law on it? And then second, the two specific questions are, is disinformation in the eye of the beholder? Is there a agreed upon or legal definition? And second, isn't disinformation primarily a business model and an algorithm problem? And third, are algorithms a form of speech?
So let me try and speak to that. So let me just back up a step, which is to say that the First Amendment model is that if we have all these competing ideas, some of them will be bunk and that the true ones will rise to the top, right? That sort of marketplace of ideas model animates a lot of First Amendment jurisprudence. And when the internet first came into being, into popularity, people who were free speech lawyers said that this is a good thing because now you don't need a radio tower or a printing press to engage in widespread speech. You can do it cheaply and easily, and there's less of a barrier to entry. Over time, and this I think speaks to the questions that you've been asking, we have a situation where people are essentially siloed with information that they agree with, even if it is disinformation, right? So Facebook, for example, allows you to micro-target, and you can say, like, I want you to send this ad or this content to this group of people. And then Facebook is in the business of trying to keep you online, looking at that so that their algorithm is not feeding you what is true. Their algorithm is not feeding you a diet of, here's some things you might agree with and here's some things you might not agree with. So you think about it, it's feeding you a diet of the things that you agree with because it's the thing that will most likely keep you online. And there, to sum up, it's in the engagement business, not in the truth business, right? And to the extent that, Mike makes the point that there are differences between what Facebook does and what a newspaper does, that's a fair point for that reason. And I think that micro-targeting and closed groups is essentially one of the biggest problems informationally that we have about disinformation, because it's really hard to cure because you're operating in a bubble. So I do think that that the algorithms that they're using are having that effect. Now, I will also say that is two more points that I want to make on this. One is, under the First Amendment, they're free to do that. You can set up an algorithm that says, I'm going to peddle a bunch of stuff that's dumb. What should happen in real life is that people will say, well, I'm not getting reliable news. If in the old days, if your morning newspaper told you a bunch of stuff that turned out to be false, you'd say, well, that's probably not a good newspaper. You wouldn't subscribe, the thing would go out of business. And in fact, you're starting to see some of that now, right? That people are looking for. So here's a recent example. People are very concerned about WhatsApp and its privacy and how that's being treated. And they're beginning to move to Signal and to Telegram, right? That is exactly the kind of thing from a First Amendment model that ought to be happening, which is that, if there's a better mousetrap, someone will build it and that's what will happen. Now, the reason why that gets mucked up, and I said this earlier, is that you end up with, a company like Facebook has so much market power that you have to deal with them if you want to get your message out. And many news organizations have to deal with them even just to get their news out. And that's a competition problem, not a speech problem. So, which I said earlier. I'll stop there.
Mike, can you weigh in?
Can I jump in on the algorithm point for a second?
Yeah, please.
Seth is right in what he says about the algorithm giving users what they want and the micro-targeting and so forth. I would take it one step further. I would say that all of the studies that have been done about what gets people to the online in the first place, and what keeps them there is content that's emotionally evocative. And negative emotions trump positive emotions. And consistently, hate and fear are very high on the list of things that are attractive to people, or not attractive, but that they gravitate towards. And so that's what we're seeing in the marketplace. We are seeing the algorithms directing people to what they want. What they want is often things that reminds them of their hatreds and their fears, stokes their fears. And so in effect, it's amplifying the worst of human emotions and making a bad problem much worse.
Okay, let me shift over to another policy issue that I think is on a lot of people's minds. Apart from it has to do with prosecutors and how prosecutors, because obviously in all 50 states are going to have to make decisions about who they're going to charge and what they're going to charge them for, and the kind of penalties they're going to seek. So in your view, is incitement, good law? I mean, whether you agree that Brandenburg versus Ohio was rightly decided or not, should prosecutors be going after people for incitement, or should they try to find other less, sorry for the word, incendiary statutes under which to deal with these issues? What is the best, as a policy matter, what is the best response to what's going on now, where we're also seeing threats against judges and members of Congress and state houses and governors who are afraid to open their state houses and all that? What's the policy remedy? Seth, you want to start? We've boxed you in on law. You can weigh in on policy if you want to.
Well, I was actually going to make a legal point. I was going to let the others go on the policy point but I was going to make just a clarifying point about something you just said, which is to draw a distinction between incitement and threats, right? They're sort of looking at two different problems. The injury that you're protecting from in an incitement regime, model, is what if I inspire somebody to actually go out and engage in violence, right? In a threats model, you're right. If I threaten to kill you, it doesn't necessarily, even if I never do anything, if you are put in legitimate fear of your life, that's the injury that you're worried about, right? So the threats and incitement are two different things. And I actually think that, notwithstanding that I'm a First Amendment lawyer, that people who are making legitimate threats to public officials ought to be prosecuted for doing that, because that's a problem, right? We can't operate and the reason for that is that then the public official isn't making decisions based on what they think is right or wrong or what the facts show. They may be making decisions out of fear, right? There were people there were news reporting that there were people who were afraid to change their vote on not certifying the election for fear of their life by people who would come after them. That's not a proper model from a speech point of view. People ought to be making decisions based on what they think about, not what they're afraid of. And it's a different problem. So I just wanted to, since you alluded to threats, I wanted to bring that legal clarification to bear. And I guess I'll think about, well, maybe Mike and Jillian want to jump in on the policy question that you asked. I'll think if I have anything to add.
The only thing I would say, just to add what Seth just said on the policy side, is we're now at a point today and in the next few weeks where you have a significant number of people in our society who have viewed what happened last Wednesday at the Capitol as a big victory and a signal that violent action leads to a desired result. They didn't quite stop the certification of the election, but they accomplished more than they ever, I think, dreamed of. And it is, I think, encouraging a number of people who are probably not so stable emotionally and healthy to think, okay, we can keep going with this. So I think whether it's under incitement or threats against officials, whatever, I think the policy issue, if I were a local governor now or a local official, I would be pretty aggressive in saying, I want to prevent violence on my state capital or in my state in the coming days. I think people are on high alert. And I'm not a law enforcement official, but if I was, I certainly would be looking, who do we know about and what are they threatening? And are we going to get to the place where there's likely violence, and what do we do to stop it legally and practically?
Well, I understand none of you are prosecutors, but back to the prosecutor question, Seth. Prosecutors have a wide amount of discretion. They can decide what they want to prosecute. What should they focus on? And again, I'm asking you as three people who are deeply devoted to free speech, but we are now really up against the limits of free speech. What should prosecutors focus on that's not a violation of the First Amendment or human rights norms? But that would kind of bring some of this under control.
Let me say this, which is that I agree with what Mike just said, which is that, and I think a prosecutor or a law enforcement official would look at it the same way, right? Which is that their primary objective at this point is to prevent more threats and more violence, right? That's what they're focused on right now, and that's a good thing. The First Amendment is not, as one justice said, is not a suicide pact with ourselves, right? We are. And from a free speech model, right? I mean, is it true that making a threat involves speech? Yes, but it's not protected. Is it true that actually inciting imminent lawless action is speech? Yes. Is it protected? No. Is it true that, in the same way that a bribe is not protected, just as another example, right? And typically speech that's knowingly false, right? Is also right. So that from a First Amendment perspective, the fact that these are the things that that people are focused on is important, that we pay careful attention to what the tests are, so we don't sweep too widely. But frankly, those are sort of the things that the First Amendment, if you're not an absolutist, the First Amendment doctrine has sort of said these are not things that we protect for good and valid reasons, and that shouldn't be a carte blanche for prosecutors to go out and start, punishing speech that they don't like under the guise of incitement or threats. But actual things that are true threats, yeah. Actual things that are true incitement, yeah. Those are things that prosecutors, they have a right to pursue those things because there are consequences to that sort of are significant ills that the First Amendment doctrine has decided we're not going to protect.
Okay, a couple more questions coming in on the First Amendment. From Shirley Smith, does the First Amendment protect a reporter's interview notes and recorded interviews that were not broadcast or published? First Amendment refresher law.
The answer to that is there's a complicated answer to that. And the answer is, and again, sorry for giving a lawyer's hedge, it depends. There is a privilege under the First Amendment and under many, many states' shield laws that protects not only a reporter's sources, but also a reporter's unpublished information. And whether that protection applies depends on whether you're in state court or in federal court. That's where the proceeding that seeks that is if somebody's coming for your notes, and whether and what kind of proceeding it is. There are different rules for grand jury proceedings, criminal proceedings, and civil proceedings. And so there's sort of a matrix of protections that reporters enjoy for protecting their sources and, by extension, their notes. And in some places, in some circumstances, it's stronger, and in some places and circumstances, it's weaker. And it's one of that patchwork, for what it's worth, I'll make an editorial comment here, was what was behind substantial efforts to pass a federal shield law that would essentially have a uniform standard for all of that, because you write a story in New York, and then all of a sudden a New Jersey prosecutor or a West Virginia prosecutor is coming for your notes. The law is different depending on where you are and where they are, and that makes it hard to be predictive about what level of protection you'll enjoy.
Okay. So I want to turn it back to Jillian for a minute, just to talk about some of the international ramifications of this. For those who have been fixated on domestic politics, understandably, the Russian dissident and Putin phone Navalny put out a statement earlier, earlier this week, in which he expressed great disgust, frankly, at the decision to ban Trump, and said, where were they? How come none of the speech against me was banned? This is going to be used by governments. There's also real fear that what's going on now in the United States is just going to empower authoritarian governments that are already taking down speech all over the world to say, okay, now we're carte blanche, we're going to ban everything we don't like. Jillian, can you talk about that? And also, what do you think that the United States, what do you think, for example, President-elect Biden should be saying about this to other countries that are going to, frankly, delight in this?
Yeah, sure. I think that there's so much to say here. I mean, I think the first point that I want to make, and I know folks are familiar with this, but it's always a good thing to remind about, is that, when it came to what happened in Myanmar, Facebook was warned about the burgeoning genocide as early as 2013 by researchers and journalists. And even long after that, there was speech flourishing on the platform that was not dog whistles, nothing ambiguous about it. I've got the Reuters report from 2018 open right in front of me, and they were, you had military generals saying things like these non-human kalarm, which is a slur there, dogs, the Bengalis are killing and destroying our land. We need to destroy their race. I mean, this was the type of speech that was flourishing on Facebook. Facebook failed to act until there was a UN investigation, and then the blockbuster Reuters report that came after it. And so again, I just have to keep reiterating that the scrutiny applied, Navalny's right about that the scrutiny applied to other countries is just so much less. And I'm not going to get the precise number right, but it's out there. There were only, fewer than 10, let's say, moderators working in the Burmese language until after all of this reporting came out. So again, Facebook was warned time and time again that this would happen, but did not act until it became a public relations disaster. And that tends to be the way that they behave. They also tend to play both sides on a lot of this stuff in other countries. Now, I want to remember all the question, Biden administration and what's happening in Europe. So real quick on Europe, I think that one of the things that would be really useful to pay attention to going forward is the forthcoming Digital Services Act, which is going to also have a global influence on the way that these platforms operate. So just like the GDPR has had an influence on the rest of the world, for instance, here in Europe, I can't access a lot of US news websites that don't comply with the GDPR, which is very sad. If your site needs to, I know that there's folks who are willing to help for free. Just like the GDPR has had that kind of influence, so will the Digital Services Act. Just like CDA 230 affects users the world over, so will this. And so that's something to look to. And there's a lot of good stuff in there too around interoperability, user controls, transparency, and remedy, which are all things that we've been asking for many years. Many of us around the world and on this panel, I think. And then lastly, in terms of the Biden administration, I mean, my biggest concern is that there is a strong push from the Democratic Party at the moment and from Biden to repeal Section 230, which I think would be disastrous. We've already seen what happens when Section 230 is amended, which happened with Sesta Fosta 2 years ago. Again, a terrible law that came from a good place, the idea to end sex trafficking, but has resulted in the again, non-legal, but the philosophical censorship of a broad range of speech around nudity, sexuality, sexual health, etc. Platforms are scared. They're scared of the liability results there. So we only need to look to that example to see what might happen in the wake of a Section 230 amendment or repeal. And so, yeah, I mean, I think that the Biden administration has brought in some great experts. I know Nicole Wong is working with the administration and the transition team, but we do need to see a lot more outreach to experts, and not just former corporate experts, but also a lot of the incredible academics and other folks who've been doing research in this area. So I'll leave it at that.
Okay. One more last question. And Mike, I'm going to give you this one because it's tough, and I know you're good at tough questions, but is the public becoming more or less supportive of the First Amendment? It seems that all of the issues that we're discussing are making the U.S. public a little bit less, maybe a little bit less supportive of the First Amendment. I'd also like to bring it in terms of what happens with some of the tech companies that actually do censor speech, or do takedowns, like Amazon taking down Parler. If they do that, do they incur risk, or do they incur popularity among their customers? Because they're in business, and so they're not just going to be looking at the legal thing; they're going to be looking at the bottom line.
So the first part of your question, Sunny, I think the thing I most worry about is that the notions of free speech become, like everything else, like so many other things in our world now, partisan, and you wind up with people that are on the, let's say, on the side of the Trump stolen election saying, we're demanding free speech, and you have liberals saying, wait a minute, you've gone too far. The First Amendment and free speech is so fundamental to our society. There needs to be a broad understanding of some of the complexities we've talked about the last hour. But it would be a shame if what comes out of this is a sense that somehow, okay, let's throw that overboard because of all the commotion that's going on in our society. Having said that, I do think, again, coming back to my sort of main concern, I do think these private companies have a much greater responsibility, as Jillian talked about, to own the content moderation, to begin to think about how they behave as responsible citizens in our society. And, it may be in some cases with Amazon or Google that they decide to take down Parler, which is certainly part of the problem. But I think we have to be really careful again about the government intervening in ways that will make it more difficult for the First Amendment to be respected and appreciated by everybody. This is a problem for all of us. It's about maintaining our democracy. And one of the things that's made our democracy so strong is that we do have a real commitment to free speech, and we shouldn't lose that.
Well, thank you. Go ahead, Jillian.
Yeah, just a quick note in there. I think it's in the resources that I sent along earlier, but one important thought that's arisen a lot this week, EFF talks about it a lot, but I've seen it from other researchers such as Dr. Joan Donovan, which is to look at these platforms as sort of different entities, right? So you've got Facebook and Twitter and YouTube and these platforms that host user speech on the one end of what we call kind of the tech stack. But on the other end, you've got platforms like Amazon Web Services, which is much closer to the core infrastructure of the internet. The law is the same, and that's really important to note, but the implications are different when we're talking about a platform like Amazon that hosts entire websites. And I think, a great example of this is what happened 9 years ago when Amazon Web Services kicked off WikiLeaks, potentially under pressure from the government, but not necessarily. It could have just been public pressure or general sentiment at the time. But that to me was a really dangerous decision. And so, yeah, of course, Parler's a different case. And I think that, there's probably legal arguments to be made around some of the speech that was happening there. I'm not a lawyer, but nevertheless, I think that we should always be a little bit more concerned when we're talking about these core infrastructure companies, as opposed to platforms of which there's a multitude.